Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020. 7:44 p.m. How does the FBI find people? The people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Alrighty, I have to show this because I missed it right at the very end, Marilyn. Marilyn, thank you. Member for 12 months says, love being here. Thank you, Marilyn. Congratulations on the 12 months in the orange courthouse by your name. It looks absolutely great. Now I need to just close this down. Find where's our new live stream. Okay, here we go. Let's pop this one out. All right, now we're ready. All right, I'm here. We can start now. Takes a little bit to get going here. All right, we're back on the record. We are continuing. It's the same day. We're starting day 3 of the. Did I miss somebody's? Kids are out playing the Airbnb. All right. Did I miss? No, I didn't miss anything. We're good. We're good. Don't doubt. Just move forward. All right, we are going to pick up where we left off, which is back up, right here. Hang on. Boom. Okay, there we go. Ready to cut on, that off. All right, we are picking up with day 3. This court. Hopefully the audio is a little bit better, less feedback. You can see the Heavenly Wood arrangement.
All rise. The Circuit Court of Dixon County is now in session. The Honorable Judge David Wolf presiding. All you have business before this court, draw nigh and you shall be heard. God bless the United States, this state, and this court.
There you go.
You may be seated.
All ye having business before this court, draw nigh and ye shall be heard.
Yes, sir. Bring out the defendant, please.
Defendant's coming. Here we go. Somebody whistling down the hall as they go to get the defendant. They're banging the doors on the holding cell. Got a little better view of the defendant.
Back on the record in the State versus B.J. Brown for day 3. I want to deal first with the requested changes, if any, of the charge that was drafted, and would simply suggest that I received an email from the state, which was copied to the defense, and in it, the state had requested 2 additional instructions, or a change in 1 instruction and 1 additional instruction. Those changes are that the state requested a flight instruction, which I think was 47.
That's 2 court cases in a row with a flight instruction.
42.18 in the Tennessee pattern jury instructions. And then the other change was to change the language of the elements of attempted first-degree murder, which is located on page 3 of the draft of instructions. In part 2 of that, they want to change to a different section of that particular pattern jury instruction. I find that, and I will be glad to hear any argument that you wish to hear, but those are the 2 changes that I've received from the state. So, Mr. Crouch, do you wish to make any other argument about any other change, or Mr. Turnbow, either one?
Judge, the reason for the the change in the attempt part of the first degree murder. Looking down at the comments specifically referred to a shooting that did not result in the death of a victim as it relates to 4.01B as opposed to 4.01A. That's the reason we're asking for that change in the attempt.
I have no objection to that particular change, Your Honor.
All right, that change will be ordered. It will be operating under that requested section rather than the language in the first draft. So then we go to the flight instruction. State wish to be heard is fairly speaks for itself, but
we'll just rely on what we put.
What they've requested in the email was that even though he is charged in one of the other counts with the commission of or the use of a weapon in a flight to avoid or flight from, I forgot the exact language, but in any event, because flight is an element in one of the other charges, they're asking that it be limited to count one of the indictment in the instructions. Mr. Spratt, do you have anything you wish to say to that? I know you have a motion to make about the count one anyway. So.
I do. I guess we can take that up all at the same time.
Yes, let's go ahead and deal with everything.
Yeah, that's terrible.
Judge, we have an objection based on the language in this indictment that the jury should not be instructed as to attempted first-degree murder based on the way that the language in this indictment, as it says that the defendant then and there unlawfully, knowingly, so forth, deliberately, feloniously, and with premeditation, attempt to kill Officer Darrell Tabor. That indictment has been read to the jury. There was an amendment the state wanted to make prior to the trial, prior to the jury being sworn, regarding the indictment, which the defense objected to. And afterwards, during the reading of the indictment, an incorrect mens rea has been read to the jury regarding this count. And so I feel like if we now instruct them on that, they've read that they think that this, if we're talking about the second degree, the lesser included charge to the jury, they've already been exposed to this knowingly language. I don't know how that can't confuse them as to how they can find guilty of attempted first degree murder based on a knowing mens rea. It dispenses with an essential element of first degree premeditated murder, which says in the statute says premeditated and premeditation and intentional. I'm assuming the reference to the first degree murder statute, it doesn't reference a specific subsection of that statute. It just references the first degree murder statute. I'd kind of like to add in there that it says, when read as a whole, knowingly, deliberately, feloniously, and with premeditation, attempt to kill Officer Darrell Tabor while acting in his capacity as a law enforcement officer, comma, as defined in TCA 3913-202, comma. The way this indictment reads is that's where the definition of a law enforcement officer is. And so you couple that with the defect that was cured over objection, where we reference, or the state referenced the wrong statute, and then you've got an indictment where you're supposed to rely on the statute one, but then you've got the wrong statute in the other. So we have the inverse problem here. I think it's dispensed with an essential element of the offense, and the jury's heard it. And so for that reason, I object to the jury being instructed on attempted first degree murder. And I'm sorry. Briefly, the state, General Crouch has provided a couple of opinions. I think they're both from this jurisdiction, one of which I believe is Judge Lockhart Mash's. I haven't had a chance to review that, but my understanding is that those are unreported cases. I'm trying to review those real quick, which would would make them, possibly persuasive once I review those in context, but not mandatory authority for this court to follow. So for those reasons, I would ask that the court.
And the essential, so that we're clear on the record, the essential element of the first-degree murder charge that you're saying is omitted in this indictment is what?
Intentional.
Okay.
And
they use the word deliberately.
It says deliberately, but I mean that's not a. I don't think that's a substitute for the plain language of the statute. So, and briefly again, with no subsection. I've read some case law where a subsection, a reference to a subsection, could cure that. I think the cases I read were with respect to the to 3917, 417, the felony drug statute, and those cases references a specific subsection. If you're pointed in that direction, then you're on notice. But if you're just pointed to the general statute, there's, I believe, 4, maybe 5 different theories for first-degree murder. So couple that back with the knowingly mens rea that's put in there, I think, and the jury's going to be instructed on knowingly, on the lesser included. So it's going to lead to confusion to where they're getting an instruction as to what it means, but they read an indictment that has that same language in there. So those are, for that reason, I'd ask that they not be instructed on that. And I can reserve, and we can argue about the extra flight instruction, or do you want me to go ahead and handle?
What is your objection to the flight instruction?
Well, if an element of the offense is already there, then, and
it's an element of the offense of one of the other counts.
It is.
First-degree murder charge.
It is. So, I mean, the jury's already going to be instructed that he's on flight. There's a different definition. The instruction on flight has to do with an inference of guilt that arises because someone fled the scene or the scene, and that they can use that as, if they choose to determine, the intent and guilt of the individual. I mean, the language is pretty clear.
He fled the scene into the scenery.
Than, the instruction on use of a weapon to facilitate their escape from arrest. I wanted to make sure that you're understanding. What they're asking is only to include that flight instruction in reference to count 1 rather than the other counts.
And I understand that, Your Honor. And other than these issues that we're taking up now, I got the email last night from General Turnbow to Your Honor and Ms. McKinney and myself. It was later on in the evening, but I have not had a chance to go back specifically review the flight instruction. So other than the issues that we're taking up now,
PPI 42.18 says the following: the flight of a person accused of a crime is a circumstance which, when considered with all of the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. Then it goes on to talk about the law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find the defendant guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all of the other evidence, when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was a flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. That's the instruction. And with all due respect, this court finds that that is in fact proven by the facts in this case, and that it is warranted as an instruction for this jury regarding count 1, and it will be inserted after the definition of the elements of murder, of attempted first-degree murder, and that will be how it will be presented.
Okay. And Your Honor, just briefly, I understand the court's ruling. Just part of my objection to that is that I don't think there was any.
So you want to talk me out of it?
No, I'm not going to talk you out of it, Your Honor. I don't believe so. I just want to put it on the record that our objection to that is that there's been no.
All right, your objection to that instruction being included, especially as it relates to count 1, which you object to anyway, is noted. So.
Yes. Thank you, sir.
Anything else then about the charge itself, other than you're going to argue about his request to not charge him on murder in the first degree, Mr. Crouch? You have case law that you're saying that relates to that?
Your Honor, I'd like to provide the court with 2 cases. I've already provided those to Mr. Spratt. One is State versus Ariel Robinson, Christopher Duncan, Timothy Schaffner, unreported, but it's out of Cheatham County, issued opinion filed on March 17th, 2021. And another case that Your Honor is familiar with, State versus Trevor Wallace, which we've leaned on a couple of times, out of Houston County, which I believe Your Honor presided over. But the first case is the most important.
Trevor Wallace case is the one that I granted the defense motion to dismiss the case based on a faulty indictment.
Yes, sir.
I remember it was.
Yes, sir.
And the Court of Appeals disagreed with my interpretation of the language of the statute.
They did, Your Honor. But that one is kind of secondary to the first case, and I want to kind of refocus on the purpose of the indictment is to give the defendant notice of what he's being charged with. It's not to instruct the jury on the elements of a crime. As Your Honor is aware, we heavily redact indictments before we even read them to the jury. They're not hearing a lot of the language that's in the jury because we don't want to risk causing a mistrial by saying the words a felony. But regardless, here's what the current indictment as presented and as read to the jury gives notice of to the defendant. 1, the indictment alleges premeditation. 2, it cites the first-degree murder statute. 3, it cites to the attempted statute. 4, attempted first-degree murder is listed as a name charge on the indictment, on the back of the indictment. 5, switching away from the indictment, we filed an amended notice of impeachment to Mr. Spratt, which clearly cites attempted first-degree murder in our range and notice of punishment. Multiple things give the defendant ample notice of what he's being tried for. We've had hearings, Your Honor, in this case where Mr. Spratt is arguing about the punishment in this case because it's an attempted first-degree murder of a police officer. There can be no dispute. Mr. Spratt's not disputing what his client's charged with. He's simply arguing that the jury may get confused by the wording of the indictment. Well, that's not what an indictment is for. The indictment is simply to put his client on notice of what he's charged with, and that's what has been done. But going to the Robinson-Duncan-Schaffner case, almost the identical situation occurred in Cheatham County where the indictment.
It's the identical language.
And here's why it's the identical language. And the courts wouldn't know this, but statewide, a system is used to auto-populate indictments when they're created. And maybe it is archaic language, but it is what it is, and it can be manually corrected. It's just so happens that statewide we are changing to a new version of our case management software. So all of that will change. But regardless, it's the exact same case. And the court ruled that the additional language of deliberate does not invalidate the indictment. If anything, the additional element of deliberately created a higher burden for the state to overcome in order to secure an indictment against the defendant for first-degree murder. This indictment is not faulty. This case, in fact, the Cheatham County case, the indictment did not list the statute for first-degree murder. it only referenced the attempted statute, and they still ruled that it was enough notice to the defendant to put him on notice that he was being tried for attempted first-degree murder. It actually left out the first-degree murder statute 3913-202 and simply had the language of attempted. So the current indictment that we have clearly is sufficient to put the defendant on notice of what he's being tried for. But I will refer to the Wallace case for just a moment, simply to say that if Mr. Spratt were to win this argument, the remedy is he doesn't just win and walk away. Double jeopardy doesn't attach because, as Wallace refers, Mr. Spratt intentionally waited till after the jury was sworn to bring this issue up. So when the defendant intentionally waits till after the jury is...
Object to that. There's nothing that says that I've intentionally waited until anybody was sworn in to do this.
Judge, we had a hearing. Mr. Spratt told me he was aware of the language.
This is argument of counsel. I take it for the grain of salt that it is.
Well, regardless, he waited. I'll retract the word intentional. He waited until after the jury was sworn to make his motion. So the remedy is a mistrial, but double jeopardy doesn't attach because he waited until after the jury was sworn. So we would just be trying this case again.
May I rebut some of that, please?
Certainly.
I didn't wait. What I told General Crouch was that I noticed the defect as far as the attempt statute, as far as the statute. That's a clerical error in the indictment. I told him, in fact, exactly what I told him is that I noticed it 12 months ago. That's a clerical error. The court is always going to, just like the court did over my objection, allow him to amend that part of the indictment. That's a clerical error. That's clear. I don't think the court erred in allowing him to do that. And I probably wouldn't even allege that in a motion for a new trial. But what happened is you're sitting there combing through this thing afterwards, and then it's read to the jury under knowingly. But that's not what I told him, so I don't appreciate that at all.
You think that this disagreement between you and Mr. Crouch influences my decision on the motion one way or the other?
No, Your Honor, I don't think it influences your decision, but we're in a court of law, and he's saying I said something that I didn't, and I do take personal.
He didn't say you said it. He's basically saying that you waited until after that you didn't wait. The fact is that this motion was made after the jury was sworn, and that's the point of significance in this court's opinion, because the Wallace case, which I presided over and granted the motion to dismiss after the jury was sworn based on my reading of the language of the DUI statute, and the Court of Appeals, Criminal Court of Appeals, reversed it, sent it back for a trial because of the fact that they said, number one, the language of the indictment was clear enough to put the defendant on notice of what he was charged with, and number two, that jeopardy didn't attach because the motion was not made until after the jury was sworn. Those types of motions and defects in the indictment typically are made before the trial begins. And that, whether you appreciate what General Crouch is saying and the way he said it, is not the issue before the court. Both of you are very able lawyers. Both of you are very impassioned for your side of this dispute. And I respect the fact that both of you take your job seriously. But it is my job to rule on the sufficiency of the indictment, and whether you agree with what he characterized or not doesn't change my decision in the case. So having given you the opportunity to respond, if you'll have a seat, I'm going to rule on this.
Thank you, Judge.
Judge, may I say one thing?
The judge says, I don't give two hoots in a rain barrel.
No, it's not. On the record, I certainly was not trying to insinuate anything nefarious on Mr. Spratt. Mr. Spratt is a very honest, good. I gave him a recommendation on Google as fantastic just this week. So I did not mean to imply anything bad about Mr. Spratt.
Maybe I should have the two of you hug it out here.
I mean, no, I was not trying to do that, Judge. So,
all right. And as I said, lawyers are oftentimes in the courtroom, and I've been in that same situation many times myself. I'm reminded of the story of a friend of mine who was hired to represent a defendant, and General Dan Alsterbrooks was the DA over in the General Sessions Court. And this lawyer was hired on a DUI case, and so he said, I'm really going to, he and General Alsterbrooks were very good friends. They went in for a preliminary hearing, and they went at it hammer and tongs. I mean, they were really going after each other. when the case got bound over to the circuit court, the lawyer was feeling pretty good about the job he had done. He walked outside, and the client said, well, I'm sorry, but I'm going to have to hire a different lawyer. And he goes, why? What did I do wrong? He says, well, the only reason I hired you is I thought you and General Osbrooks were friends, and you obviously can't stand each other. So that's the way lawyers operate. They have to present their cases in an impassioned way and do it because they believe in their cause. And Mr. Spratt has certainly shown that he is doing everything he can to represent his client within the bounds of the law. General Crouch is doing the same thing from the state's position. I don't take any offense in the fact that the two of them have tried this case in a very professional way, and sometimes our passions get the best of us. So that doesn't help me what goes on between the two of you in deciding the case. What does help me is the instructions given by the Court of Criminal Appeals. And as I referred to the Wallace case, General Crouch is correct. That case clearly indicates that if I do grant your motion to dismiss that indictment, then, or to dismiss count one of the indictment, the state can simply go back to the grand jury, get another indictment, and come back in and try him on that charge again. I do not believe that that is in the best interest of the parties. And the reason for that is because in this other case, which is the state of Tennessee versus Ariel K. Robinson, the Court of Criminal Appeals made certain observations about the indictments that are returned in cases. And they state, and I'm referring to page 17 of that opinion, indictments are reviewed from an enlightened standpoint of common sense and right reason rather than from the narrow standpoint of petty preciosity, pettifogging technicality, or hair-splitting fault finding. It goes on to say that in this case that I'm dealing with, the Robinson case, the language of the indictment was exactly the same as the language in this. It was an attempted first-degree murder case, and the language in that stated exactly the same thing as this indictment states, that the grand jurors of Cheatham County found that the defendant then and there did unlawfully, knowingly, deliberately, and feloniously, and with premeditation attempt to kill Frank Burnett. And this particular situation, that's the exact same language that's used here. The Court of Appeals, the Court of Criminal Appeals, in that Robinson case went further on page 18 to state the following: the additional language of deliberate does not invalidate the indictment. If anything, the additional element of deliberately created a higher burden for the state to overcome in order to secure an indictment against the defendant for first-degree murder. Accordingly, any error in the grand jury process caused by the addition of deliberately in the indictment ran to the defendant's benefit, not his detriment. Further, the indictment clearly states that the alleged offense occurred with premeditation and was a Class A felony. And that, under my reading of this indictment, is exactly the same situation we have here. The jury, when they deliberate this case, will be given in the final charge, as you've seen, all of the elements of first-degree murder and all of the elements of the attempted first-degree murder. So they're going to be instructed on the law correctly, and the indictment itself is intended to give notice to the defendant of what he's charged with, as well as to set the case before the court. So for those reasons, the court denies the motion to dismiss count one and finds that the count one of the indictment on attempted first-degree murder is a valid indictment and a valid charge and should go to the jury. Now,
I forgot to give the internet to Carrie H.
Regarding the charge, we're going to make the charge that I've given you with those two changes, flight and the second section on that other section. Those two changes are the only changes I'm making, and I'll then have that printed and we'll be ready for presented to the jury. Mr. Spratt, you backed up, so I assume that means you're going to stand up. So.
Matter. Do you know, Your Honor, what, are we going to print those now before we bring the jury in, or are we going to get those?
Print what?
The instructions with the changes?
Well,
I got several copies.
It's going to be, we have a jury sitting back here that's been waiting since 8:45, an hour, waiting to take this case back up. We're not going to print that before the jury. We'll give you a copy of it before you make your closing statement. What we're going to do is we're going to conclude whatever issues I have to take up outside of the presence of the jury, Then we're going to bring the jury back, conclude the state's proof, offer the defendant an opportunity to present any proof that he may want to, although he's not obviously required to. And when that is done, I will then make copies for everyone of the final charge, and then we'll let you have your final argument, and we'll go from there. Anything else? All right. Then let's take up whatever other issue there is to be heard outside of the jury's presence.
Judge, we're going to have a brief out of jury out hearing on the issue of some recordings from the Dixon County Jail.
That's
and
what
the
we're waiting
state's
for.
first witness in that will be Deputy Howell.
Deputy Howell, raise your right hand. Let's place you under oath.
It's going to be quick. It's basically we don't have it.
Good morning. Will you state your full name for the court, please?
Deputy Greg Howell,
Can we spell your last name?
Howell,
Where do you work?
Dixon County Sheriff's Office.
How long have you been employed there?
Almost 11 years.
And have you ever been employed in the corrections and jail area?
Yes, sir.
And how often have you worked there?
First 4 years at the Sheriff's Office.
Okay. So are you familiar with the booking area of the Dixon County Sheriff's Office?
Yes, sir.
And are you familiar with the booking area where the defendant in this case was housed?
Yes, sir.
Are there individual cells within the booking area?
Yes, sir.
Are there cameras within those cells?
No, sir.
Okay. So if somebody is inside of their cell, there's no camera?
No, sir.
And do y'all put audio recorders inside their cells?
No, sir.
All right. Is there a video surveillance camera like we might see in the courtroom in the general area of booking?
Yes, sir.
All right. It records video?
Yes, sir.
Does it record audio?
No, sir.
And it never has?
No, sir.
All right. I'll pass the witness.
No questions.
No questions.
Thank you, Officer Howell. You may stand down and resume your duties.
Yes.
We knew that was going to be short.
Pickles, Aaliyah Brown.
Brown.
That's the deputy who testified, corrections deputy who testified yesterday. Still no relation. Let's see if she's doing the bun again. Looks like she
Deputy
is.
Brown, if you'll come back around, I'm going to ask you to be placed under oath again, please.
Solemnly swear or affirm that the testimony in this case the whole truth and nothing but the truth, so help me God.
Deputy Brown, will you state your full name again, please?
My name is Aaliyah Brown.
And spell your last name?
B-R-O-W-N.
Thank you. And are you employed at the Dixon County Jail?
Yes, sir.
And what do you do there?
Well, not at the jail anymore. I'm in the patrol division, but at the time of the incident, I was.
So I want to refer you to September the 20th, 2023 through September the 28th of 2023.
Mm-hmm.
Were you employed at the jail at that period of time?
Yes, sir.
I think September the 20th of 2023 was the intake date for the defendant, B.J. Brown, in this case. Does that seem right?
Yes, sir. I believe so.
All right. Was he just being housed temporarily at the Dixon County Jail?
Yeah, as far as I know, he was here for court.
Okay. So an intake date of September 20th, 2023, and a release date of September 28th, 2023, that would be the 8-day period that he was kept at the Dixon County Jail?
Yes, sir.
All right. So you created a report that was testified to yesterday that says on September the 22nd, 2023, I, Corporal Brown, was conducting a security check in booking when inmate B.J. Brown asked that his pie flap be opened.
Yes, sir.
First of all, September the 22nd, do you think that's the date this incident happened, or is that date wrong?
I think it's the 21st.
Okay. One way or the other, it's the 21st or 22nd.
Yes, sir.
Did you approach the defendant's cell?
Yes. So with a security check, you scan a tab on each cell and booking and mark what they're doing, laying down, sitting on bunk, things of that matter.
So you had to actually look into his cell?
Yes, sir.
And to your knowledge, there's no video cameras inside an individual cell?
No, sir.
All right. Were you wearing body camera at this time?
I was, but they don't run continuously.
Okay. So when you had this incident with the defendant, you didn't have body camera running?
No, sir.
All right. So there was no recording made?
No, sir. Not as far as I know.
No recording to be preserved?
No, sir.
All right. And there was no camera in his cell?
No, sir.
Okay.
I've heard of a pie hole.
Mr. Spratt?
Why, Deputy Brown, why is it that your body camera wasn't running at that time?
That's not part of policy within the jail. If an incident occurs, then we're to turn it on, but it's not like the typical Axon cameras.
Okay, so you manually activate that if
Yes, sir,
something's going on?
You do.
Okay. And somebody had just threatened to shoot you?
Yes, sir.
And you didn't turn it on?
No, sir. It was conducting a security check. You don't typically record those.
Okay. And who did you talk to about this first?
Lieutenant Hoope.
Lieutenant Hoope.
Yeah, she's no longer with the jail, but she was the security officer at the time.
Okay. And what day did this happen on?
I believe it to have happened on the 21st.
You believe it? Is that just from your memory?
Best of my recollection.
Best of your recollection? Okay. And how long after that point did you go report it to Lieutenant Hoope?
I mentioned it to Hoope that day. When the warrants officers came to get Mr. Brown for court, it was communicated to them. They communicated up their chain, and that's when Captain Andy Davis requested that it be notated.
Okay. Did you speak with anybody else about it other than?
No, sir, not to the best of my recollection.
Okay. Did you ever speak to Deputy Epps about it?
No, when I relieved Epps that morning, he mentioned threats had been made, but that was the scope of it.
Okay, that's all the Deputy Epps said to you?
Yeah, that threats had been made towards him.
Same day?
I relieved him that he worked night shift, so I'm unsure if it would have fell before or after midnight.
But one
yes,
shift
sir.
right after the other?
Yes, sir.
Okay. And so that's when Deputy Epps says to you, he's made threats to me, and this is on September, you believe September 22nd or 1st, somewhere in there?
I relieved him from the booking post, so to speak, so he kind of gave me a rundown of, events that had happened the previous shift.
You had no further interaction later that week with Mr. Brown?
When the warrants officers came to pick him up for court, of course, I took the keys over there and they handled it from there. But outside of that, no, sir.
Okay. And I'm talking about like the 6-7 days later when he was about to be transported, you had no?
I didn't, as far as communicate with him, not really, sir.
With Mr. Brown?
Yes, no, sir.
Okay.
No, sir.
What about Deputy Epps? Did you have any communications with him later in the week about it?
No, sir.
Okay. Those are my questions, Your Honor.
Can you redirect for her?
No.
So
let's go ahead and have her step off. Is there anything else about this issue before we bring the jury in?
The jury didn't hear that.
She was testifying yesterday when we adjourned for the day. Any reason that we can't just resume from that point? All right, let's bring the jury in. You can just stay where you are. So.
Mind the gum, deputy. Mind the gum. Beep, beep, beep. Jury door open. Cindy Ludu. I think it is. It's a curlicue on her head. I think it's a spiral. Keeps it out of her way, that's for sure. The jury's all talkative this morning. They know it's their last day. I only know Cindy Lou who is not more than 2. Got out of bed for a cup of cold water.
Morning, Deputy Brown.
Juror still, we're waiting on one. I know you're anxious to get
I'll
started. We still have one more. Ladies and gentlemen, thank you for your patience. These delays that we have where you are left sitting back in the room are my fault. You should not attribute that to either one of the parties in this case or hold it against them one way or the other. I leave you back there so that I can deal with things that I think are important to be done outside of your presence.
The judge is
so please, if you're going to hold it against anybody that you're back there twiddling your thumbs, hold it against me and not either one of them. So, all right. We had adjourned yesterday during the cross-examination of Officer Brown, and Mr. Spratt was questioning her about something, and we adjourned to allow that to be investigated. That's been done, and we are now ready to resume the cross-examination. Officer Brown has already, or Deputy Brown, has already been sworn in this morning, and so she is under oath as we proceed. So, Mr. Spratt, you may resume your cross-examination.
Thank you, Your Honor. Deputy Brown, you say that Mr. Brown made these statements on September 21st?
Yes, sir. I believe it to have been September 21st.
Okay. You believe it to have been September 21st. And you, around what time of day?
I know it was before lunch.
What's your shift? Just
at that time, my shift was 0700 to 1900.
Okay, so the military time that was my next question.
Yeah,
so,
sorry.
7 to 7.
Shifts.
Okay. All right. So you came in at 0700, which is 7 a.m., right?
Yes, sir.
On the 21st, right?
Yes, sir.
Okay. And may I approach again, Your Honor, briefly? I'm going to ask you to review that again and in your head and not read it out loud.
I got you.
Can you?
This is for impeachment. It's a very brief statement.
Do you believe it may have been September 22nd?
I think it was the 21st, sir.
Okay, so are you saying there's a typo in your
I believe so, sir. I think the correct date is the 21st.
So you believe it was the 21st?
Yes, sir, I do.
Okay. And when an incident occurs, you wear body-worn camera?
Yes.
Let me back up. You wear body-worn camera?
Yeah, it's separate from the Axon again, but it is a body camera.
Okay. And when an incident occurs, you manually activate that,
yes,
right?
Yes, you do, sir.
Okay. And so you did not manually activate that camera?
No, sir. Not in conducting a typical routine security check. No, sir.
Okay. So then you didn't feel threatened enough to where it was an incident that needed your body camera turned on, did you?
No, sir. I didn't go back to his door and, continue the situation.
Okay. Those are my questions, Your Honor. I'll pass the witness.
Turnbull.
Judge.
Deputy Brown, just to reiterate, you don't know Officer Tieber at all, do you?
No, sir.
Okay. And this thing that we're talking about here occurred in Dixon County?
Yes, sir, it did.
All right. And there was a door between you and Mr. Brown, wasn't there at this time?
Yes, sir, there was.
And so was the statement made like through a flap in the door or something of that nature?
The flap was closed. The door was closed. So through the door, yes, sir.
And what was the statement he made to you?
He said he would shoot me just like the other cop.
Nothing else, Judge.
Recross?
No. He is? Oh, come on.
And language like that did not cause you to feel that you needed to videotape this?
No, sir. Like I said, I didn't go back to the door nor try to argue further with the situation. Just let that be the end of it.
And you believe you put the wrong date when you reported it?
Yes, sir. I believe the correct date to have been the 21st of September.
Have you talked to anybody else about this since it all happened?
No, sir.
You've never mentioned it again?
No, sir.
Have you talked to anybody about it in the last 24 hours since you were here, since we were here? Well, not 24 hours. Have you talked to anybody about it since yesterday?
I spoke with my FTO that I'm currently with and just kind of let him know what happened while I was here on the stand. But outside of that, no, sir.
What?
Okay. So you did discuss your testimony then?
With my FTO, yes, sir.
Okay. Those are my questions.
Who is your FTO, Deputy Brown?
Epley.
And he's not related to this case or a witness in this case or has anything to do with this case?
No, sir.
All right. That's all I got.
Anything further?
That's part of
Thank you, Deputy. You may sit down and you may resume your duties.
Thank you, sir.
You may call your next witness.
Judge, that's the conclusion of the state's proof and the state rests.
All right, the state rests. Ladies and gentlemen, I know you've been anxious to get back across the hallway there, so I need to deal with a couple of matters that should be short, but if you will step across, we will come back in just a few moments. So.
Greeners, just saw your comment. Oh my goodness. I can't even highlight it.
Counsel, I'm giving you a copy of the final charge. Ms. Pam, I hand that down to you.
Thank you.
All right, the state is rested, Mr. Spratt.
Are you going to testify?
You wish to address?
I do, Your Honor. Judge, at this time, we would make a motion for a judgment of acquittal.
It's not going to go there.
As to count one, the attempted first-degree murder. We renew our objection again based on the language in the indictment, and would argue that Mr. Brown on the video, he's charged with a crime of flight. The evidence shows
this judge is so
all of the
smart.
This
is not going to fly.
Defects. I'm sorry, trying to remember how they were characterized. The defects in the windshield, directly where Officer Tiber were sitting, the vast majority of those were all outward where Officer Tiber had returned fire. So Mr. Brown clearly think it's his conscious objective was to get away. In fact, I think had the gate not been there, he may have kept driving. Rather than that, I don't think, based on our objection regarding the indictment, we would ask that be dismissed. And then two, we don't think the proof conforms to that statute, Your Honor.
The judge has to look at this in the light most favorable to the prosecution.
There is sufficient evidence as under the standard that I'm required to consider that there is sufficient evidence that would allow this case to go to the jury on all three of the remaining counts, and that the court found that a reasonable person could find that there is enough evidence to find that the defendant is guilty of premeditated attempt to commit first-degree murder. So the motion for judgment of acquittal is denied. Does your client wish to testify? If not, we need to do a Momon hearing. So.
Judge, can I briefly step out and discuss what a Momon hearing is?
Just a few moments. That should have already been discussed. So if you want to take it back to the holding area and let Mr. Spratt come through the visiting area.
It should take less than a couple of minutes.
It's probably going to take longer to do the shuffle, to take him back into the holding area and go around than it needs. He's just going to explain what is happening to the client. The client has to make these calls. This is not a decision the judge can make for him.
I'll step off, and when I resume, we'll conclude whether or not Mr. Brown is going to testify. And go directly into closing statements, since you have a copy of the chart.
All right.
I honestly am so surprised that this case is even went to trial. There seems to be a mountain of very credible evidence. This is not circumstantial evidence, but a mountain of very credible evidence that places the defendant at the scene. I'm going to turn this off just for a minute. We have, let me go over just some of the evidence that's been brought in. We have a cell phone pings that show the defendant traveling from Louisiana all the way up to Tennessee. Those pings basically take him from another crime scene, which the jury has not heard about, and that was a murder. Take him from that position all the way up to where he was pulled over in a traffic infraction. As soon as the traffic infraction, the traffic stop began, that officer rolled his dash cam camera, and so we have that entire stop caught on camera, and the officer also started his body cam video as well. So we have the entire interaction, which was very short, on 2 law enforcement cameras. He also happened to have pulled over in front of a building. I can't remember the name. It's a construction company. It's a little road. He pulled out outside the fence, and he pulled up on and was caught on audibly or visually on, I believe, 3 camera systems there. And so this is recorded 5 different ways. Okay, so we have a great view of the defendant and where he's going, what he was doing, how long it happened, what was said. The audio was captured as well. We've got that. We've got the defendant. Then he jumps out of his car. He fires the AR rifle at the police officer, who returns fire through the windshield. Then the defendant runs off. The officer who was wounded, who was shot twice, was wounded. Who was shot twice in the arm, wounded. He goes around, hides behind the back of the car, and waits for backup. It takes about 4.5 minutes for backup to arrive. The defendant runs down the fence line and around the back and sort of heads towards the creek. And that creek happens to be about 700 something feet away, or 700 yards. I can't remember which one it was. That creek has to be where they found the firearm in the water, in like crystal clear water. You could see it on the bottom of the water. They took a picture of it. You could see it. They took a picture above the water, and you could see it down below. He's got the orange shoes. He has bright orange, very unique, distinctive shoes, which are visible in both the crime that happened down in Louisiana and the shooting here. The outfits match everything else. You've got him then on the run. A manhunt goes on for about 2 days. They end up finding him after he's broken in and stayed and hidden in a couple sheds. They find his shoes, wet shoes, in the shed. They end up taking him into custody. After they take him into custody, they Mirandize him, and then on a recorded statement, he admits to some of these elements of this crime. There are some things he doesn't admit to, which is weird, like the shoes. He says, not my shoes, never wore those shoes. And his shoe size is 8, and he never would have worn a 10 or something. We'll see. But anyway, there is so much evidence against this defendant that I don't know how he thought he had any hope of getting anything but a conviction here. But judge is back now, so we're gonna listen to how this turns out and see if he's going to testify in his own defense. All I need to know today is what a pie flap is. The pie flap is the door in a jail cell that, I guess, the pie goes through. That's where you put the pie. A dearth of evidence, and all of it credible.
What is your plan regarding any further testimony from your client?
No, Your Honor, Mr. Brown's not going to testify. He understands, and we're ready to execute it.
Mr. Brown, if you'll come to the podium. I'm going to ask you to raise your right hand. Let me place you under oath.
Solemnly swear or affirm that testimony in this case will be the truth.
The lawyer's like elbowing for room at the lectern.
State your full name for the record.
B.J. Brown.
Mr. Brown, you are represented by Mr. Spratt, and I know you and he talked about it, but do you understand that you have an absolute right to testify on your own behalf in this trial, and that if you wish to testify, no one can prevent you from testifying?
Yes, sir.
You also understand that you have an absolute right not to testify, and that if you choose not to testify, no one can force you to testify, and the jury can draw no inference from the fact that you did not testify.
Yes, sir.
You understand that if, have you understand what you're charged with? Have you talked this over with Mr. Spratt, and you and he discussed what's in your best interest?
Yes, sir.
And do you believe it's in your best interest not to testify in this case?
Yes, sir.
So that he's made a knowing waiver of his right to testify. You want to have him sign that form? I know you were writing on something.
No, I don't have one.
You have a MoMA form.
So without him testifying, we're not sure if they're going to call any other witnesses. If they're not, then the defense is going to arrest right away. They have no burden to carry here. Judge has a nice chair. I'm a little jealous. I mean, I have a nice chair as well, but I can still be jealous.
All right, thank you, Mr. Brown. You may have a seat. Mr. Spratt, do you have any other witnesses you wish to call?
Defense rest, Your Honor.
Whoa, nothing.
All right. Well, when the jury comes back in, I'm going to ask that question on the record so that they can know that you're not presenting any other proof. All right, we're ready for the jury.
Your Honor, briefly, just very briefly, before they come back in, is the court wanting to go straight into closing arguments? Or are we going to review time to review the final charge one last time before we do that?
I'll give you 10 minutes.
Okay, so they're going to have another break. We're going to skip that break.
Pardon? We've given you the final charge, the draft of the final charge before. The only changes are those that I've made this morning. So
this is a speedy trial.
If you wish to, but I'll give you 10 minutes to look it over, and we'll go directly into closing arguments. The state will open, and then you'll be given yours.
Okay, thank you, Judge.
All right, we'll stand in recess for 10 minutes.
All rise. Judge.
Okay. I just want to say that this court is so refreshing to see where the judge is so much in control of his courtroom compared to what we saw. Very different style in the Crumbly case, where we had the judge in the Crumbly case at times seemed to not know what she could and couldn't do in the courtroom. She was asking the media if she was allowed to tell them what they could and couldn't film while they were in her courtroom. We had all sorts of arguments between lawyers, speaking objections, arguments back and forth in the presence of the jury. This is very, very different. I prefer this way. This is how I like to see it. Almost mid-sentence, if it becomes a speaking objection, the judge will excuse the jury and send them out. And I like it. Ricky, I got this chair as a gift. I think they got it from Sam's Club, though. We do a lot of shopping at Sam's Club because we have a big family, and the size of packages they have, that's the size we need. All right, so we're going to skip ahead just briefly and get through this break. We're going to be starting closing arguments. The state's going to go first. I'm not sure if they bifurcate it. I get like a 1, 2. They should get a 1, 2 because they have the burden. So they'll go first and go last. They should get about the same amount of time, though. So there we go. All right. I'm a big fan of this court. Lawyers and judges of the Troconis trial have been good to watch, too. I've heard that's a good one. Brandy did catch up on that over the weekend if you missed it. I don't know who gifted Brandy her chair, or I heard she got a lot of flowers, too, which is awesome as well. This is the one time I get to use that word. I don't know how to use it in any other sentence, Greeners. Thank you. Here's what this court has going for it. First of all, I think the decor.
When the jury comes to the trial, I'll be asking for their style for any proof.
Yes, sir.
It's heavenly. The wood is they've turned the lectern because it's going to be facing the jury now, but it's beautiful. The use of electronics is very well done. There's a little bit of work that can be done audio wise, but it's livable. And he is fair. He's fair. He listens and he makes good judgments. He's not emotional. He doesn't even get caught up when the attorneys are squabbling back and forth.
Ladies and gentlemen, the state has rested their proof, so Mr. Spratt, does the defense wish to offer any proof?
The defense rests, Your Honor.
The defense has rested as well, so you have heard all of the proof all of the evidence that you're going to receive to be able to decide this case. The next step will be the closing arguments of the parties. And the state, as I explained to you, will always go first, and they'll have an opportunity to make the opening statement and the closing statement after the defense if they choose to make a statement. So, state may address the jury.
Good morning again, ladies and gentlemen, and thank you for your attention through this trial. I know sometimes it's probably tested your patience, but I do appreciate your good attention through the trial. On the evening of June 27th of 2022, Officer Daryl Tieber, sitting right there, got ready for work. He's a police officer for the city of Ayden. He put on his patrol uniform, marked uniform. He testified just like the one he's wearing there, except with short sleeves. Got in his marked patrol car with blue lights equipped on it and went to work to serve the citizens of Ayden, Tennessee. This was a normal evening for him, but it wasn't going to turn out to be just any other evening. Before the evening was out, Officer Tieber was going to have a terrible thought run through his mind. You heard him testify right there on the stand. After those first 2 shots were fired, I thought I was going to die. He made an ordinary traffic stop on B.J. Brown, the car he was driving. He made a traffic stop because he couldn't see any license plate on it. It was Officer Tieber's job to look into that, serving the citizens of Ayden. So he makes the traffic stop, and what happens?
Sit down in your car, sir. (106 Central). Carded.
Couple of things I want you to note about that video. Officer Tieber has the microphone in his right hand. He is mid-sentence when these shots start. See, to him, this was just an ordinary traffic stop, but this man had other ideas in mind. He'd already made preparations for what was going to happen. Officer Tieber didn't know it. It was just an ordinary traffic stop. You see him mid-sentence have to throw the microphone down, grab his service weapon, and return fire. Done amazingly quickly between his training and adrenaline and thinking that he was going to die.
Stay in your car! What's wrong? Stay in your car, sir! What's wrong? Stay in your car! What I did? Stay in your car! Come on! Stay in your car, sir!
things I want you to note about this video. Mr. Brown pulls up almost all the way to the fence at McCaskill Construction. And what does he do immediately upon stopping? He immediately gets out of the vehicle and engages the officer verbally. He does this for several seconds, giving him time to calculate, giving him time to plan what he's going to do next. And he sees the officer's reaction. Because he's standing up, he's outside of his vehicle, he can see what Officer Tiber is doing. And he knows Officer Tiber engaged him. You hear it multiple times. Sit down in your car. Sit down in your car. I will come to you. And then Officer Tiber sits down in his car and gets on the mic. All of which B.J. Brown can see because he's standing up outside of his vehicle. So this is what we're talking about today. An attempt to unlawfully kill the victim, Officer Tiber, done with premeditation while Officer Tiber was performing his law enforcement duties. Oh, we know number 3. We see the blue lights in the video. Officer Tiber's making a traffic stop. He's got his uniform on. He's in his marked patrol car. But I want to take the other 2 one at a time and just go over a few things with you about each one of them. And the first thing here I want to point out, 14 shots. This man fired 14 shots out of that rifle at that officer. 14 shots. While Officer Tiber is sitting in his patrol vehicle and Mr. Brown is outside. I want you to look at this. This is the dash cam video, and it's slowed down. And I want you to pay attention carefully to Mr. Brown's first 2 steps. I want you to look and see what it, and I'm going to scoot out of the way so you can see very good. Where were Mr. Brown's first 2 steps? Were they running away? They weren't running away. They were going at Officer Tiber. He moved a little bit away from the car, but his steps were towards Officer Tiber's patrol car. He wasn't running away. He had intent to kill Officer Tiber. He moved towards him. He fired 14 rounds. Now, after that, you see him kind of hop to the side. But I want you to remember, what happens after he fires 2 shots? Officer Tiber is able to throw down the microphone, get his service weapon, and start returning fire. See, Mr. Brown at that point no longer has the advantage. He's no longer the only one standing out with a rifle shooting. Officer Tiber is able to return fire, possibly saving his life. And Mr. Brown takes off. That's when he leaves. He doesn't get out of the car and run. He gets out of the car and goes towards his patrol car trying to kill him with his 14 shots. Next, I want to talk a little bit about premeditation. And like I told you in the beginning, the judge is going to give you the law, and I expect that this will be what the judge tells you, a part of it, about premeditation. A premeditated act is one done after the exercise of reflection and judgment. Did he have time to exercise reflection and judgment? Premeditation means that the intent to kill must have been formed prior to the act itself. It's not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. So those are the things that we're looking at for premeditation. This is that second element that we looked at on the 3 elements. If we go to the next slide, I want to talk to you a little bit about what Mr. Brown's actions were. See, none of us here can read minds. There's been some talk about this in the trial. So how can we tell what a person's intent was? The way we can tell is we look at their actions. We look to see what they did. We look to see what this man did. He obtained a rifle full of rounds that was described by the expert as penetrator rounds while he was in Louisiana. He got a rifle that was full of rounds for penetrating things. And he drove from Louisiana to Tennessee. And you heard in his interview that took him several hours. It took him all day, giving him plenty of time to reflect, plenty of time to think about what it was he was going to do. Why did he have that rifle? In his interview, he said that he was going in Memphis to visit the memorial for young Dolph. But you heard Special Agent Angie Valley testify as far as where he went. He didn't spend any time in Memphis. He drove straight through. I think Agent Valley testified he may have stopped at a red light or something, but the time was consistent in driving straight through. He didn't go to that memorial. That's not why he had that gun. He drove all the way to Erin, Tennessee, where something happened that he didn't know when or if it was going to happen, but he'd had time to think about it. He'd had time to plan what he was going to do. And then Officer Tiber pulled him over. He'd had hours to reflect on this situation. What's going to happen if this happens? So he sees McCaskill, he pulls almost all the way up to this fence. What's behind the fence? Woods. There's nothing back there. Again, he still has time. And then what does he do? He gets out of the car immediately and engages the officer. What's he doing now? Well, we talked about the reflection and judgment. Now is his plan to kill Officer Tiber. He's had time to reflect on it. Now we're getting towards the implementation of this plan. Gets out, immediately engages the officer, sees what he's doing, sees if he has a shot, plans it out. Then he gets back in the car. He told us in his interview the rifle was in the back seat. Gets in the car, reaches to the back seat, to the rifle that he'd already put there, and was ready to go. He gets the rifle out, he aims it at Officer Tiber, and he fires that rifle 14 times. See, that's the intent to kill. After he exercised reflection and judgment, and he had decided to do that before that 14th shot was fired. He decided to do that before the first shot was fired. He decided to do that while he was driving up here from Louisiana. And after that, he runs off in the woods. After Officer Tiber starts firing back at him, and it's no longer just a one-way shooting, he starts running. He hides in the woods, and he leads officers on a multi-day manhunt.
So he pulled you over, and just because he pulled you over, you got out and shot at him?
Fainted. Fainted. You lost consciousness?
I was very tired. Did you see the officer was a white cop?
Mm-hmm.
So if it was a black cop, would you have done the same thing?
Yeah.
Just because he pulled you over, you got out and shot at him. Did you see it was a white cop? Yeah. If it was a black cop, would you have done the same thing? Yeah. You see, it didn't matter if Officer Tiber was white, black, green, blue, yellow, or purple. This man wanted to kill him because he was a police officer. That's why he wanted to kill him. He was a police officer. And I want you to remember, B.J. Brown was driving without a license. B.J. Brown was driving a car that wasn't registered to him. B.J. Brown had drugs in his car, 170-something pills. Agent testified to you, methamphetamine. And then B.J. Brown had a warrant out for his arrest. It didn't matter what law enforcement officer pulled him over. He was gonna kill him. That's all he cared about. There's one more thing that I want you to think about. Why do you think Mr. Brown immediately got out of his vehicle? Remember, he had a rifle. If he decided to stay in his patrol or in his vehicle when the patrol car came up behind him, how easy is it to shoot from the inside of a vehicle when you have a rifle, trying to get it up to your shoulder and trying to aim? If he gets out of the car, he can see what's going on. He can see how the officer is going to react. He can see where the officer is at, and he can easily aim his rifle. He'd had time to plan this. He didn't have time to plan that when he stopped, because you saw when he stopped, he immediately got out. That had to have been thought through beforehand. He immediately gets out knowing that he'll have the advantage at that point. And he attempted to kill Officer Tiebert for doing his job. He'd premeditated it. He intended to kill him because he was a police officer who was doing his job. And we ask you to find him guilty of it.
That was a quick statement. Now on to defense, who gets one shot at this.
Judge, the defendant will waive closing argument and ask that the court proceed to instruct the jury on the law. Thank you.
Waives closing. We have nothing to say. We have nothing to say.
And these to the jury, please. Ladies and gentlemen, I'm going to give you your individual copy of the final charge of the court.
Defense doesn't have a burden. It's all the burden rests entirely on the prosecution. So they can rest and not have anything to say.
Right, ladies and gentlemen,
they don't have to do a closing either.
Ladies and gentlemen of the jury, the defendant, B.J. Brown, is charged in count 1 with the attempted first-degree murder. Necessarily
about 2 weeks
included
ago.
within a charge of attempted first-degree murder are the lesser included offenses of attempted second-degree murder and attempted voluntary manslaughter. The defendant is charged in count 2 in the indictment with the crime of unlawful possession of a firearm during the commission of a dangerous felony. The defendant is charged in count 3 with the crime of unlawful employment of a firearm during the flight or escape from the commission of a dangerous dangerous offense. Necessarily included within a charge of unlawful employment of a firearm during the flight or escape from the commission of a dangerous offense is the lesser included offense, unlawful possession of a firearm during the commission of a dangerous offense. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Houston County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. As heretofore stated, in count 1 in the indictment, the defendant is charged with the crime of attempted first-degree murder. Any person who commits the offense of attempted first-degree murder is guilty of a crime. For you to find a person guilty of attempted first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, 1, that the defendant intended to commit first-degree murder, and 2, that the defendant did some act intending to cause an essential element of first-degree murder to occur, and at the time believed that the act would cause the element to occur without further action on the defendant's part. And 3, that the alleged victim was a law enforcement officer who was engaged in the performance of official duties, and the defendant knew or reasonably should have known that the victim was a law enforcement officer engaged in the performance of official duties. Knew and known means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Intended, intending, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Law enforcement officer means an officer, employee, or agent of a government who has a duty imposed by law to maintain public order or to make arrests for offenses, whether that duty extends to all offenses or is limited to specific offenses, and to investigate the commission of or suspected commission of offenses. The essential elements necessary to constitute first-degree murder are 1, that the defendant unlawfully killed an alleged victim, 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious, objective, or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that he did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. The flight of a person accused of a crime is a circumstance which, when considered with all of the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself from for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find the defendant guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all of the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was a flight by the defendant and the reasons for it and the weight to be given to it are questions for you to determine. If you find the defendant guilty of attempted first-degree murder as charged in count 1 of the indictment, you shall so state and proceed to count 2. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of attempted first-degree murder, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of attempted second-degree murder. Any person who commits the offense of attempted second-degree murder is guilty of a crime. For you to find the person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, and 2, that the defendant did some act or caused something to happen that would have constituted second-degree murder if the defendant's beliefs at the time he acted had in fact been true. The essential elements necessary to constitute second-degree murder are 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly is previously defined. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of the person, then the killing of another, even if not the intended victim, would be second-degree murder. If you find the defendant guilty of attempted second-degree murder as a lesser included offense of attempted first-degree murder, you shall so state and proceed to count 2. On the other hand, you will not find, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of attempted second-degree murder, you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of attempted voluntary manslaughter. Any person who commits the offense of attempted voluntary manslaughter is guilty of a crime. For you to find a person guilty of a criminal attempt, the state must have proven beyond a reasonable doubt that the defendant intended to commit the specific offense of voluntary manslaughter, and that the defendant did some act or caused something to happen that would have constituted voluntary manslaughter if the defendant's beliefs were at the time he acted had in fact been true. The essential elements necessary to constitute voluntary manslaughter are 1, that the defendant unlawfully killed the victim, the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. If you find the defendant guilty of attempted voluntary manslaughter as a lesser included offense of attempted first-degree murder, you shall so state and proceed to count 2. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of attempted voluntary manslaughter, you shall acquit the defendant of this offense and proceed to count 2. As heretofore stated in count 2 in the indictment, the defendant is charged with unlawful possession of a firearm during the commission of a dangerous offense. Any person who commits the offense of unlawful possession of a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant possessed a firearm. And 2, that the possession was with the intent to go armed during the commission of or attempt to commit a first-degree murder. And 3, that the defendant acted intentionally. Firearm means any weapon that will or is designed to be or may readily be converted to expel a projectile by the action of an explosive. If you find the defendant guilty of unlawful possession of a firearm during the commission of a dangerous offense, as charged in count 2 in the indictment, you shall so state and proceed to count 3. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of unlawful possession of a firearm during the commission of a dangerous offense, then you shall acquit the defendant of this offense and proceed to count 3. As heretofore stated in count 3 in the indictment, the defendant is charged with the crime of unlawful employment of a firearm during a flight or escape from the commission of a dangerous offense. Any person who commits the offense of unlawful employment of a firearm during the flight or escape from commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant employed a firearm. 2, that the employment was during the flight or escape from the commission of or attempt to commit first-degree murder, and 3, that the defendant acted either intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct, when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct, when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct, when a person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. If you find the defendant guilty of unlawful employment of a firearm during the flight or escape from the commission of a dangerous offense as charged in count 3 in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of unlawful employment of a firearm during a flight or escape from the commission of a dangerous offense, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of unlawful possession of a firearm during the commission of a dangerous offense. The elements for unlawful possession of a firearm during the commission of a dangerous offense are set out in count 2. If you find the defendant guilty of unlawful possession of a firearm during the commission of a dangerous offense, you shall so state. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of unlawful possession of a firearm during the commission of a dangerous offense, you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you reach the verdict, you will return with it to this courtroom and your foreman or forelady will announce it. If you have a reasonable doubt of the guilt of the defendant as to the offense charged in the indictment, you shall return a verdict of not guilty. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report you find the defendant guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. If from the proof you find the defendant has committed a crime other than that for which he is on trial, you may not consider such evidence to prove his disposition to commit such a crime as that on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides motive. That is, such evidence may be considered by you if it tends to show a motive of the defendant for the commission of the offense presently charged and or the defendant's intent. That is, such evidence may be considered by you if it tends to establish that the defendant actually intended to commit the crime with which he is presently charged. The crime charged in each count in the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. When you retire to the jury room, you will first select one of your members as a foreman or forelady who will preside over your deliberations. When you reach the verdict, you will return with it to this courtroom and your foreman or forelady will announce it. In reaching your verdict, you shall first consider the offense charged in each count of the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to that defendant. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of that particular defendant's guilt of that offense, you shall find the defendant not guilty, and you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least, if a lesser included offense is included. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you have unanimously reached a reasonable doubt, or you unanimously have a reasonable doubt of that particular defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in each count of the indictment, you shall return a verdict of not guilty as to that count. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report you find the defendant guilty and will name the offense agreed upon. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. The defendant is charged in 3 separate counts of this indictment. Although the cases are being tried together, they are separate and distinct cases. You must decide each case separately on the law and the evidence applicable to it, just as though each case is being tried separately. You'll be asked to render a verdict as to each count of the indictment. You are reminded that you are required to report a verdict or a failure to agree on all counts of the indictment. Ladies and gentlemen, to assist you in your deliberations, I prepared a verdict form, and that will go back with you for your deliberations. It deals with count 1. It states, as to the charge in the indictment, the charge of attempted first-degree murder, the jury finds the defendant either guilty or not guilty, and allows you to make that determination. Then you move to the next one. As the instructions state, you only consider lesser included offenses if you have found not guilty or a reasonable doubt of guilt as to the original charge. With that, you may now retire to the jury room and begin your deliberations. I would tell you that if you will have certain exhibits that will go back with you, but if you need to see anything regarding the video or the photographs that were demonstrated on the screen, you will need to necessarily come back into the courtroom to be able to see that. At this point, before you retire to begin deliberating, I will select randomly 2 of you who will be alternates, and that means you will not have to decide this case.
I'm going to end the poll while he's doing that. We're going to do a new poll. It was 95 to 5. 95% felt guilty. 4% said not guilty. I'm going to do one more poll to make it a little easier and clearer.
Number 200, William Roberts.
Robert, you are excused as a juror for this case. If you have anything back here in the jury room, then you need to go out and we'll be able to go ahead and have you get your items before you leave. Then is that all right?
Sure. No.
All right. We'll need you to do that before.
And number 79, Gerald James.
All right. You will also be the second alternate, so you can go with the officer and let him help you with that.
You have anything in the back room?
No, do you want me to put this back?
I just need your notepad and your juror badge.
You can keep the charges for your entertainment in the future if you wish to do so.
The new poll is up for those that are challenged finding the right button.
I say all I need is your notepad and your juror badge. You can just sit in this chair and it's all through. You still don't have one.
All right, the rest of the jurors may retire to the jury room to begin your deliberations.
Okay. As they go to the jury room, we're going to fast forward.
Court will stand in recess pending the return of the jury.
Let's see. So what time do we have right here? We're at 1:39, 1:50. Let's skip ahead. They deliberated for... Wait. Let's see. I need to get time. 3:02. Okay, we're going to start right here. That's going to give us time. All right, this is not a surprise to anybody, but we have a verdict. We have a verdict in the Tennessee versus J.B. Brown trial, or B.J. Brown. Sorry, got that mixed up. This is an attempted murder trial. The defendant is accused to have fled from Louisiana, where he is also accused of committing a murder. Running to Tennessee, getting pulled over by an officer in a regular traffic stop, and instantly, in just moments, escalating that traffic stop from a regular stop to a shooting where he jumped out of the car with an AR-style rifle and fired 14 rounds into the police car, which Officer Tribort, I can't remember his name, which officer was sitting in. Officer was struck twice in the arm, but was still able to return fire with his service weapon through the windshield of his car. The defendant was not struck in this process and managed to escape and evaded capture for about 2 days, hiding out in the woods with no food whatsoever. It was actually his hunger that drove him to closer to civilization, where he was captured. After he was captured, he was taken to the police department, where he was interrogated after a couple hours of sleep. And yes, he did confess to many aspects of this crime, though he left out some parts. Refuses to admit to wearing the shoes that he was seen with on video exiting the car. He refuses to say that he shot first, or that he fired his gun at the officer instead. So we have a verdict here. In moments here, the jury's going to come back into the courtroom and read their verdict in the presence of the judge, and the defendant will find out if they believed his story, which was told only through him in the interrogation room, because they provided no evidence, no witnesses at all, no defense. This was a prosecution-only case, and it is appropriate to have a prosecution-only case, because they bear the burden of proof. All right, we're going to fade the music down here a little bit. I know you guys are having a dance party over there. Welsh lady, I see you. I see you. All right, deliberation appears to have been about, let's see, what time is it now? An hour and 15 minutes, roughly. There we go. All right, judge is back. He's holding a note from the jurors. Let's listen in. Do we have audio? Judge, don't forget us. Judge, let us in. Let us in. We might be waiting for the defendant here. It looks like they're waiting to bring him in. That's what's happening here. So this is a case that took place while we were watching the Crumbly trial. It took place a couple of weeks ago, and it happened in Tennessee. Let's see, bailiff's present. Front door. Should have kept the music going. Didn't realize it was going to be this little much of a delay. Here we go.
All right, Ms. Leslie, we're ready. The jury has returned or has advised that they have reached a verdict, so we're going to bring the jury in.
We're going to close out the poll here. It looks like 62%, 63% maybe voted yes, and 37% voted also yes. So that it looks like we're unanimous on this one. there's so much evidence. Very compelling too. More public observers here in the courtroom than we've had throughout the trial.
Step off for one moment. I'll be right back.
All right. Court's in recess.
Judge will be right back. He probably forgot a pen or something. Maybe his phone.
Yeah, they've got one. Everything must come back.
All right. This court's back in session.
He had his calendar. He needs his calendar. He has to set dates.
Whenever the jury's ready to come out, we're ready for them.
That red book is his calendar. If he has to set a date, say for sentencing or something like that, he'll be using that book. That is the demonstration calendar he used to yell at an attorney for being late. You are correct, screeners. But it's also fully functional. It's not like the model bullet that was displayed in this case, which is not fully functional. More bailiffs present here.
Gentlemen, I'm advised that you have been able to reach a verdict. Is that correct?
Yes, sir.
Foreman or forelady, would you please stand? As I'm going to go over the verdict form with you, and if you'll just let me know the response. As to count one in the indictment on the charge of attempted first-degree murder, how does the jury find the defendant not guilty or guilty? As to count two of the indictment, on the charge of unlawful possession of a firearm during the commission of a dangerous offense, does the jury find the defendant guilty or not guilty?
Guilty.
Count three of the indictment, does the jury find the defendant guilty or not guilty of the charge of unlawful employment of a firearm during the flight or escape from the commission of a dangerous felony?
Guilty.
All right.
That's three guilties.
Have a seat. Hand that, if we will, to them. Ladies and gentlemen of the jury, I need you to all signify by raising your hand if this is the unanimous verdict of all 12 of you. Let the record reflect that all 12 have indicated it is a unanimous verdict, and I affirm that verdict. Ladies and gentlemen, I thank you for your time. I know it's taken up 3 days of your life for us to do this. It's an important case, as you well know. We were going to now deal with the setting of a sentencing hearing for me to deal with the sentence to be imposed. But you have our thanks, my thanks, and the thanks of all the parties involved for your conscientious service as a juror. I wish I could tell you that would terminate your service for this term of court, but I can't do that because we always need jurors. So if you'll just check that sheet they've given you as to whether or not you need to call back in.
They might have another trial
today. So thank you for your help. And if you'll go with Officer Howell, he can let you get anything you need out of the jury room and turn in your badges and your notebooks. Thank you.
So they just completed a 3-day attempted murder trial, and they might have to come back for another. I've never seen that. I've always seen jurors that once they do one trial, they're done.
Sentencing hearing.
Just preliminarily, we'll waive the 45 days on that.
Well, I would like to set it in either February or March, simply because of the fact that that's March is my regular term here, so it would make sense to be able to do it on that day.
Doesn't he travel? Doesn't this judge travel between different buildings?
The 12th of March is the date for our criminal docket call with jail cases. It might be better to do this one on the 11th, which is bail cases. That's usually a shorter docket. March the 11th.
My only problem with that is I have a vehicular homicide leading right up to that, and this being a life without parole case, I need just a little bit of time to prepare for that more than a normal sentencing hearing. If we could do it later in March, March is fine.
We can do it on the 26th day of March. That's the violation of probation day where there is bail, 26th day of March.
That'll be fine with me, Your Honor.
Mr. Crouch?
What time would that be? What time would that be?
We can set it for that afternoon if that would work.
I'm teaching class that morning, but if we could, that afternoon, yes.
Teaching a class?
In-service training, yes.
All right. 1:30 in the afternoon on the 26th day of March, and we'll need to have an order for a pre-sentence report. Go ahead. Mr. Brown is remanded to the custody of the Sheriff's Department pending the sentencing hearing on the 26th. That is, at that time, the court has reviewed the statute and agrees with the state that the determination of the sentence, including whether or not the defendant will be sentenced to life without parole, as that new statute provides, will be determined by the court after that sentencing hearing.
Your Honor, the final matter, and I promise this is the final matter, could I ask that Mr. Brown be transported to Dixon County a couple of days earlier?
Unless you have any problems in transporting him a couple of days before. 26th is the date, so that's a Tuesday, if we could bring him here on over the weekend.
That would be great.
Would that be possible? All right, that's fine. To show that he'll be transported prior to that time. Anything else before we adjourn this case?
No, Your Honor.
All right, then we stand adjourned.
All rise.
All rise.
Court's adjourned.
All right, there's our last look at the Heavenly Wood courtroom. It's a beautiful one. It's a beautiful courtroom. All right, before we break for the day, I wanted to pop over. I heard something spicy was going on in Judge Boyd's court, so I paused it just a little bit. I want to just take a peek. Let's see here. Let's move this over there. Move this over here. Do we have any audio?
2022 CR 4248A,
Yes,
State
now
of
you did
Texas
some
versus
video.
Jose Angel Ruiz. Mr. Ruiz, if you come down, please. Could our parties announce for the record and counsel you on this side?
Okay, there we go. Something's going on here, and I
If
want
you
to
could
see
repeat
what
that.
happened here. No one can
Yes.
get their positions. right.
No, the deputies wanted it changed for security issues. And are you Mr. Ruiz? All right, we're here on a motion to unseal documents, motions, and orders that were sealed. State, have you had a chance to review the defense's motion? All right. So defense is asking for, sure. All right, that's denied. All right, do you have an order? Do you have a motion?
I have a motion and an order.
All right, do you have a motion that's been filed? All right, so State, do you have any objection to an oral motion?
She's objecting to YouTube.
It's been heard. I believe there
hasn't been
some
heard. The
kind
motion to refuse. I'm sorry.
This issue has been heard. I believe there was a written motion previously, but it was ruled on. I don't have an objection to her re-urging her motion.
All right, you can re-urge your motion.
And Your Honor, it has never been heard. I asked to have you, Your Honor, I asked you to recuse yourself only for the purpose of the YouTube. That was the only reason I did it, and it was refused. But
All right, and that was denied by by another judge, correct?
Yes, because I couldn't prove it under civil procedure. However, I'm requesting and objecting right now because my client has a presumption of innocence, which has been discouraged by showing him in prison clothes in front of a live audience of over maybe 1 million people. I don't know. But his presumption of innocence has been
Judge Boyd
damaged
is like, I wish.
because of this YouTube experience.
All right, that's denied.
With my client sit in the jury box, so he wouldn't be in front of the YouTube.
We're here on a motion, so he's here, or either he can sit at the table. He can either sit at the council table or he can stand here.
He can sit at the council table.
All right, so y'all go back and sit at council table.
Your Honor, it makes my client look guilty.
All right. And off the record for a moment. And Bashan, that other person is coming back, correct?
Judge, I told her to. I don't think she got it.
Okay. All right. Thank you. Because there's somebody who's going to come down to speak with her. All right. We're back on the record. So, State, you've had a chance to review this motion?
Yes.
All right. State, do you have any motions that have been filed under seal?
Your Honor, the District Attorney's Office, we have not filed anything under seal. I cannot speak to whether there was maybe an outside party who was complying with the subpoena for the defense had sent out, but nothing as far as the state of Texas in our capacity from the District Attorney's Office has been filed under seal.
All right. So defense, who has filed motions under seal?
I don't know, Your Honor. I only have access to the public computer that the rest of the public has access to. It shows as sealed, 2 sealed documents with different numbers attached to them on October 31st. It includes also 2 sealed motions. Now, it's my understanding that my co-counsel, Ms. Efron, filed motions for payments for mitigation experts.
Is there a microphone on?
I'm sorry.
There's a little bit of distraction. I didn't hear the name. Ms. Who?
She's struggling with the tech.
Does that work?
I can hear you now.
You have to. Oh, when I'm talking. Okay.
I didn't hear the name of the person you said co-counsel.
My co-counsel is. Oh, it just stayed on? Okay. My co-counsel is Lorraine Efron, and she filed motions, I know, for fees for the various people that are attached to our case. And
So
sure that
just
was
one
October
second.
31st.
Just 1 second. So let's start with this first one you're talking about. October 1st, 2023. Is that a motion that the defense filed that you want unsealed?
Not necessarily. I found out it is a defense. Unfortunately, Your Honor, what we received on the computer, and I made copies for myself, not for anybody else, but when I received on the computer, mentions a motion and order filed. I don't know who files it. We don't always know. Miss Mitchell has been helpful as much as she can be, but I'm not sure. The reason for this particular motion to open unsealed was because of when the plea was entered.
No. Let me stop you. This is my question. So October 31st, 2023, are you asking that motion, whatever it be, even if it's a motion that was filed by the defense for your expert or whatever, you want it unsealed?
Yes, Your Honor.
State, do you have any objection to unsealing a motion that was filed on October 31st?
No.
And to the clerk, are you able to look and see who filed that motion?
She filed a motion to unseal documents.
Only my supervisors.
Okay.
I don't have access to sealed motions.
All right. November 1st, 2023.
She doesn't know who filed it, but she wants it
State,
unsealed.
is that your motion?
Sealed motion order. I don't know what it is.
No, that was not our motion.
Okay. November 15th, 2023. State, is that your motion?
No, Your Honor.
November 16th, 2023. Is that your motion?
No, Your Honor.
November 22nd, 2023. State, is that your motion? All right. And what other dates on here? Because you mentioned any other dates unknown to movement.
Well, I have at my wherefore paragraph, any other motions and orders in the interest of justice that are under seal. The reason for this is because during the plea of Katrina Mendoza, the co-defendant, on August 7th, after she entered her plea, you turned off the YouTube and you had a private conference with the defense counsel and state, and there's no record of it. And so I'm wondering, is there an order there somewhere? I don't know. I don't know what happened in that conference. YouTube was turned on again when your conference was over. And I don't know what went on with it.
Well, if people would have been in courtroom that day, they probably would have heard what went on. But you're asking for any other dates unknown to movement. You are not asking for orders for any other dates, or are you?
Welcome, Broken Bakers.
Unseal any and all documents, motions, and orders in the interest of justice.
All right. So what I will do, State, if you have no objections, I will grant the motion to unseal the motions that she's asking to be unsealed. and I'll do an in-camera inspection because I don't know what these motions were sealed as to. I don't know if it's something that everyone is supposed to see or not, because I don't know what it is.
Your Honor, I just pulled up the co-defendant's cause number 2022 CR 4248B, and it looks like a lot of the dates she listed do correspond to what appears to be sealed motions in that case. So perhaps she's referring to, I believe the defense counsel is Todd McRae. I don't know if he needs to be here.
Yes, he would need to be here. If these are motions that you're asking to be unsealed, and they're in the co-defendant's case, and it's motions that that defense attorney has filed on behalf of their client, you may not be entitled to have those motions unsealed.
Is that a ruling, Your Honor, or are we going to have another hearing on this?
Oh, we're going to have a hearing, and Mr. McRae will be here. And Mr. McRae may have an objection to the unsealing of motions that were filed in his case, perhaps by him, perhaps by the state. So this is the court's ruling with regards to the October 31st, 2023, November 1st, 2023, November 15th, 2023, November 16th, 2023, and November 22nd, 2023, and any other dates unknown to the movement. Court is rescinding any rulings that were made previously because the court assumed that these were documents that were filed in your client's cause number and not the co-defendant's cause number. So what will end up happening is the attorney in that case will be here, and that attorney can raise objections if he so chooses to having documents that he may have filed on behalf of his client and their cause number.
What I was quoting you was all their cause number. It's the same cause number, it's just an A or B difference.
No, but here's the thing. If that defense attorney, Mr. McRae, filed sealed motions for his client, it may be experts for his clients, and he may not want those unsealed. And the question becomes whether or not you are allowed to unseal or have unsealed sealed motions that he has filed that, for example, if he hired an expert for his client and he does not want the state or you to know what the findings are of his experts, he has the right to keep that sealed. So he needs to be here to see if he has any objection. And I made my ruling previously thinking that these dates were dates that were under your cause number, but the state is telling me that these are dates under the co-defendant's cause numbers and not your own.
That's true.
Oh, well, then Mr. McRae needs to be here.
School is in session.
For the next one as well. I'm asking for a copy of the PSI for Katrina Mendoza.
No, with regards to the PSI, Mr. McRae has no ability to object to your seeing the co-defendant's PSI. That is an order that you need to have heard to see if probation will allow you to view that.
I have to file another motion in order on that?
Yes.
Thank you. The other thing I'm asking for is a transcript of the witnesses that the state intends to call at time of trial.
What transcript?
Transcripts of the statements. The child who was a sister of our decedent Mercedes Lozoya is listed as a witness.
Well,
we'd like her a transcript of that, as well as anybody else they're going to call as a witness.
When you say transcript, was there a testimony, or you're talking about them speaking to the police?
Voluntary statements.
All right. If they have statements, it should be in your discovery.
It's not just. We did not get a copy at all of young Jordan's. She was 6 years old at the time. I believe she's about 8 now.
It's a forensic interview, Your Honor. The disc has been in the file. The state has given defense counsel actually. I brought the file down to court for multiple days for defense counsel to view with a separate clean computer.
Yes.
We've made it accessible.
Yes, technically they did, Your Honor, along with 3,000 plus other evidence of discovery. Personally, I put in close to $200 hours out of court, just me. Lorraine Efron has a whole nother bunch of hours. Out of that, I would like to request a transcript of Jordan's, rather than just her testimony, a transcript of it, the voluntary statement.
All right, so let me ask you this. This statement made, this alleged statement, was it made in English?
It's made in English. Yeah.
All right, then you all need to view it. The state has given you opportunity to view it. I know that in this court, and if I'm wrong, correct me, I think during the holiday, I want to say November, Thanksgiving, I had the deputies have your client brought over and for you all to watch the video. So I'm not ordering them to transcribe a video. You need to watch it with your client. And the court has made the courtroom accessible for you all to do that. I'm not going to order them to have somebody transcribe a video that is in English.
Your Honor, excuse me, but we were never presented in court, and I thank you for the time you did give us, but for over 3,000 bits of discovery, which is it's 2 inches thick. When we ultimately file our 3914 motion, when we ultimately file, it's about 2 inches thick. We did get to see videos. We got to see certain statements. We never got to see Jordan's. We have to go to the office to see that. I'm requesting an actual transcript of her voluntary.
All right,
statement.
that's going to be denied for them to do a transcript. Deputy Mejia, is he able to come over here Wednesday to view a video? They will bring him over Wednesday to view a video.
Of Jordan.
There's multiple. I can bring them all over.
All right.
In particular, that one.
She just wants Jordan's. Is that correct?
That's fine.
No.
Had an opportunity to view the statements.
Now, my question is, do you just want them to bring Jordan's statement over?
That's fine. Yes, Your Honor.
All right. So she just wants Jordan. And Mr. Ruiz will bring you back Wednesday and you can see the video.
Your Honor, I have 2 other things that are not. One of them is from an order that Judge Harrell granted back on August 28th. It was about the medical examiner. She was subpoenaed pursuant to that order to be here on a given date, and she didn't show up. She had some other reason. She sent instead a pile about 1 inch thick of papers that weren't sealed, not sealed, but were not attached with a rubber band. And when I was reviewing them, I realized there was no certification of the records custodian as to the validity of those documents. So I'm going to do myself, with your permission, write a letter and ask for this custodian to send us another packet that has been notarized, if you're all right with that.
Oh, I'm not in charge of that at all.
Your Honor, I do have a brief response to that, just because Dr. Molina is, she's very responsible and she does stay on top of her things. She was in contact with me that day, and she had prior obligations, but she did send her assistant with all of the documentation that they had to, it was just a subpoena to bring documentation, Your Honor. Mm-hmm. They brought the documentation, and then when we were conferring just in court, that it was acknowledged that really they just need Dr. Molina for a 705 at trial. So that's why she did not appear.
But we tried to do it beforehand in the interest of economy of the court. Even still, the fact that the documents were presented loose with no certification by the records custodian, how can we possibly use those records? I'm just asking that we get another copy certified by the records custodian before we go to trial.
All right, I'm not going to order that. If you all want something, you just pick up the phone, call the ME. You said you've already subpoenaed her in the records, then that subpoena is still in place.
Thank you. And one other thing that you referred, because I wasn't in this case until a year after it began, and I would like to get a copy of judge's notes in the file with your permission.
Sure, here's the docket sheet. The notes are on there. And this record is public.
Excuse me, Your Honor, I don't believe it's the same as the actual notes that are in the file.
This is the entire file. This is the court's, this file here, this is the court's file. I don't have anything else. If it's not in this file, it doesn't exist.
There's nothing written in the file, in other words. It's all on that.
It's the docket sheet. I write everything down on the docket sheet, and any orders or motions or any letters that have been received from the jail by your client, it's in here. This is the court's file.
So if I can get a copy of that, you're talking about.
Oh, we're not. Here's the thing. We're not going to have the copy machine at back and use the copy machine for you to make copies on this. You're more than welcome to write down whatever you want to write down from it. You're more than welcome to do that.
Can I send somebody to do that? Or can I send a records copier company to come and copy that?
Here's the issue with that. This is a legal document. This file
does not leave the court.
The custodian of this file, technically and legally, is the district clerk's office. So you would have to clear that with the district clerk office if they would let some outside party come in, take this file apart, and get copies of it.
But in there is the year before I was appointed. It has all the comments that the court made. Is that correct?
What is in here is what is in here.
February 7th was the arrest date. It's the date of Mercedes' death. I was appointed and actually activated in April 2nd. There's that whole year took place. Lorraine was replaced by Debbie Burke, who was hired and then withdrew. Mrs. Burke was involved for 9 months. I don't know what happened during that time. I don't know what orders the court made. I don't want to run afoul of anything.
It's on the docket sheet, and any motions that were filed that are not under seal are in this file. And any orders that were heard are in this file. If it's not in this file, that means that it's not in this file and no order was heard.
Okay, thank you.
I don't know how this could have gone.
Can I have the same access to Katrina Mendoza's file?
I'm not in charge.
Technically, they're all
Here's the thing, and I want people to hear me clearly because maybe I'm not communicating properly.
Thank you.
These files are the court's files. And when I say court's file, I don't mean they're Stephanie Boyd's files. I mean, these are the files to the 187 District Court. The custodian over these files are the district clerk. If anybody wants some inside party to come in to copy this file, you need to speak to the district clerk about it and see whether or not they are allowed to come in to make a copy of the file. I am not the custodian of the records of the file. Do I write things in the file on the docket sheet? Yes, I do, but I'm not the custodian of records. So if you want to bring some third party in to make a copy of John Doe's file, Amy Doe's file, whoever it may be, that needs to be cleared with the district clerk's office because they are the custodian of records of these files. I am not. Okay. And what I can tell you is the normal practice in this court, if there is a hearing held, if I give a ruling on something, I write it on the docket sheet. That's where we are.
This may have gone a little better for this attorney had she not first filed to have removed Judge Boyd from the case because she has a YouTube channel.
That would be all. Thank you, Ernest.
All right. So, Ms. Ferguson. All right.
We need another hearing date.
Does anyone have any objection to the court calling Todd McRae, see if he answers, so that we can have a setting on whether or not he has any objections to the motions in his client's case that were sealed being open or unsealed?
I have no objection.
I have no objection.
All right. So we can go off the record.
Judge, make the call. Make the call. Here we go. She's going to jump on the phone and talk to that other lawyer who made the filings. We're going to sit here until it comes back. Actually, we're going to skip ahead because we can. Let's see, just 1 second. Right here. Skipping ahead. This was her afternoon docket. Was it playing? Oh, there we go. Okay.
All right. So what I'm going to do is I'm going to recall this case
if you want to follow
Because
this
I know
one,
our
this
jury
is the date you need
trial
to know.
is coming up in March.
Well,
So we're going to come back on February 20th
a week from
to
tomorrow.
hear your motion to unseal.
what time, Your Honor? Next.
9.
Is that a realistic time, Your Honor? Or
It is if everybody is here on time. If everybody's not on time, then no.
Thank you.
But I will be here at 9.
Is that a realistic time?
All
Your
right,
Honor?
so we'll do February 20th at 9.
And Wednesday we can come.
Wednesday, they're going to bring they're going to bring the video down of Jordan, and you'll be able to see that.
Thank you.
And I'll bring another clean laptop. A laptop that doesn't have any other outside applications.
So I can't copy it.
No, no.
All right.
I can't copy it. I can't copy it. No.
And just so everybody knows, on Wednesday, defense counsel needs to be in here the entire time that's being viewed. The deputies are not. If defense wants to leave to go to another court, then he's going back. Okay? All right. Thank you.
Thank you.
All right. So that happened. That happened earlier today. I wanted to end. Oh
yes.
Yeah. You can go. You can go. I don't know what that case is about. I'm scared. I'm worried that it's a terrible one. There are children involved. It sounds like there was a death involved, and it might have been a death of a child. So not an easy case to follow. But that lawyer, she's spinning her wheels. I don't think she's getting anywhere though. I don't think she's gonna be successful in that. Sounded like it sounded like a murder. It did. But it might be like a child abuse homicide type situation, which terrible. As we know, for those that are trying to follow the other cases that are going on in the world today. All right, the courtroom is very entertaining. She is so good. This is why we sent her flowers. We love her. We love how she deals out justice, and at the same time, she's mindful of the defendant and what is in their best interest, even if it's not what they want right then. A lot of people don't want to go to jail, but she sees somebody whose life is spinning out of control, and she might sentence them to 4 years and then counsel them and say, hey, you're on the state's dime now. You can go to school for 4 years. You can come out with a degree and change the whole trajectory of your life. It's like a study abroad, only you're not going abroad. Interesting stuff. All right. Her off-the-record speeches are the best. Yes, they are. SF in Texas, I did shave. I need to shave again. I've got this a little scratchy going on, right? All right. I appreciate everyone who stayed with us throughout this day. We finished up this trail. We have to look for something to look for to hunt down tomorrow. We're going to look for some cases. If you see a case that's coming up or the one that has coverage, even if it's a smaller case, please let us know. We're looking for different options. We are going to get to the point where we're going to have too many cases to follow, but right now it's a little bit thin. I guess judges don't want to have a jury seated on Valentine's Day. I don't know why, but anyway, we're going to give put that little call out there. If you see any cases out there that you think we can follow, give me a little a jingle on the burner phone. Or send me a text message would probably be better, so we can check it out. Not every case that's televised we're able to cover. It's technical, it's crazy, but that's how it is. We'll try. We'll look at it and see if it's right for the group. All right, that is how we're going to end today. I want to thank everyone for being here. It's been a wonderful day. I appreciate all of you. Thank you very much. It was a lot of fun getting through this. I loved watching Judge David Wolf. That he's an interesting judge. Really, really like him. I love the courtroom. Love the Heavenly Wood courtroom that they have there. The way they implement technology, if they could just tweak the audio just a teensy bit, it would be perfect. It would be my favorite courtroom. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning at 8:30. Ashley says I'm going to go back and actually watch this trial. Highly recommend it. Thank you. All right, 8:30 in the morning. another opportunity. We are going to actually redirect to Dr. Joe, who's going to be on at 6, which is in an hour. So if you have not left yet, please don't leave yet. It's a good opportunity to go over there. Land on the like button. Just put that DNA all over the like button. Make sure we know that you were there. And also ring the bell and make sure you're notified when he goes live, which will be in about an hour. So he's going to be live tonight with the story behind juror number 1. He does juror number 1 and his wife. Great people on tonight. And I think there'll probably be an opportunity for you to ask questions for a little Q&A. And it's always good with Dr. Joe. He was here earlier in the chat. It was great to have him here as well. Hope his live stream goes wonderful tonight. So please support that if you have time. All right. Thank you, everybody. Have a good night. We'll see you in the morning. Bye-bye.